The reason by the Supreme Court clearly is sound, is in accord with the practice in other jurisdictions around the world, and also clearly borne out by the letter and spirit of relevant provisions of the Constitution.
This applies to forming of quorum for business as well?
Yes, because indeed the Constitution itself was quite clear. Whenever it seeks to exclude a member presiding, it says so clearly. So you see that for the commencement of business, ordinary business in Parliament, it says with the exception of the person presiding. But such exception is not made in the case of forum for decision making. So when it comes to forum for decision making, the member presiding, if he's a member of Parliament, clearly will be included in the record of the quorum.
In terms of subsequent parliamentary business, I mean, as Minister for Justice, you expect that this will resolve the matter and avoid the scene that we saw when the Deputy Speaker attempted to vote previously?
Oh, yeah, definitely, yes. I mean, those things clearly were needless and were really inspired by mischief, because all those mischief makers should have known that the practice in other traditions, whenever the person presiding is a member of Parliament, that person is not precluded from exercising his right to vote, exists. So I think those scenes of Parliament were really unwarranted, and we really hope that they will not be repeated again. The Supreme Court has brought clarity on the matter and it should guide the nation going forward.
There are only two outcomes. It's not like a football game where there will be a draw. There will either be a win or a lose. But in this case, I think there's actually no one lost, because I think the Constitution wins, the people of Ghana win, and this is the best decision that I think we should have had. It puts clarity on the law, but despite the fact that some of the reliefs that I was seeking were not obtained. But there's a far-reaching decision that has been made by the Supreme Court today, to the extent of striking out portions of the standing orders, and this is very good for all of us. It puts clarity on the rules of Parliament, and indeed it makes all of us citizens. And I think I would probably use this opportunity to invite all of us to be participants in the democratic credentials of this country. We all have to play our roles to ensure that we get the best outcomes of our constitution. This is just one of the things that we'll be doing going forward to ensure that the difficult decisions in bringing the sort of cases to the Supreme Court for clarity to be put on some of the issues that borders on sometimes illegality are all put to the past.
Attention has just been drawn to a ruling of the Supreme Court on the matter as to whether a person presiding as Speaker, consistent with Article 102 of the 1992 Constitution, which provides for the quorum, and Article 104, can exercise a vote whilst presiding. Our attention has been drawn to a very disappointing ruling of the Supreme Court of Ghana, which more or less amounts to a judicial interference in time-tested parliamentary practice and established conventions everywhere in the world, in civilized democracies, including the United Kingdom. The presiding officer's vote is discounted. So it's not for nothing that Article 102 provides that a person presiding shall have no original nor custom vote. The Supreme Court, to put it aptly, this ruling is judicial support for e-levy, nothing more. Judicial support for e-levy for a struggling economy.
They have given their ruling. We have heard. But I believe that there's a reason why our standing orders say that Parliament is the master of his own affairs, and that the procedure in Parliament resides in the bosom of Mr. Speaker. For me, I cannot for the life of me be part of what I would deem an illegality, which would be that the person presiding in the House would take part in a vote he's superintending over. And so I do not know what position my leadership would take or my party would take, but my principled position is one that states that anyone presiding be it Mr. Speaker or any of his 2 deputies, has absolutely no business taking part in the vote on the floor of the House. And we will employ every legal means within the parliamentary procedure to ensure that this long time tested practice of Parliament, which is 30 years old this year, will be upheld. Until the Lord Justices decide to start expunging parts of the Constitution, like 1045, for us to see that the application of the law is not skewed and imbalanced. I do not see why anyone who has a conflict of interest should be allowed to vote. Because 1045 says you have a conflict, do not vote. Why did the Lord Justices go silent on the standing orders of Parliament that say that a chairman of a committee does not have a vote? A chairman of a committee in Parliament does not have an original vote. So why are they not saying that that is also a deprivation of his constituents? I mean, we pray the Lord Justices. Their role is to bring clarity, and not rather lead us into confusion and obfuscate what the facts are. The law is clear. We have heard them. They've passed their ruling. But Parliament, we are masters of our own procedure. We will carry out what we believe is right on the floor of the chamber. I'm suggesting that I will protect the independence of Parliament from any interference by any other arm of government. We have stood up to the executive. We will stand up to any other arm that seeks to interfere. Or I will stand up to any other arm of government that seeks to interfere in the work of Parliament. And I can tell you that I am sure most of my colleagues are of like mind, because this is a dangerous slope. Tomorrow, you would have someone go to court, and then the Supreme Court may also rule and say that they are holding someone criminally liable for comments he made on the floor of the House. This is a Pandora's box we would not and should not open. The last time Joe Wise tried to move from his seat to cast a vote, I was polling agent for the NDC. You remember what happened? My position hasn't changed.
You resisted.
Our anthem enjoins us to resist oppressors' rule. So when I do my work as a member of Parliament on the floor of the House, they should charge me for treason or contempt or whatever. They should come and charge me. I'm in the chamber. That's why I said to you that we must be careful the door we want to open. So right now, when I carry out my business on the floor, you want to subject me, acting in lawful capacity as a member of Parliament, not outside Parliament, on the floor of the House? You want to subject my actions to the whims and caprices of the judiciary? Let's be careful where we are going in this country. All because of an e-levy.